Hearing in the appeal of the Queen on the application of Noone against the Governor of Her Majesty's Prison, Drake Court, and another.
Yes, Mr. Witham.
My Lords, I appear with Mr Fitzpatrick for Helen Rebecca Noone. Learned friends Mr Giffin QC and Mr Kovacs QC appear for the Secretary of State in this matter, the respondent. Can I just mention two matters of housekeeping first? Before my Lords, there are two further bundles. Unfortunately, the printers missed out some of the Bennion extracts, so we've recopied those. It may be that I will only refer to them rather than take you to those in any event. The other bundle is of some provisions which appear in some of the provisions that I'm going to take my Lords to. We say that they're not relevant to this appeal, but it may be that my Lords will want to have them in order just to refer to them later. So there's nothing particularly important about those two matters.
Yes, thank you.
My Lords, the appellant was sentenced to multiple concurrent and consecutive sentences with a totality of 27 months, made up of a sentence of 22 months, 3 terms of 4 months concurrent to each other but consecutive to the 22-month term, and 1 month consecutive to all of the other sentences for contempt. In fact, she didn't turn up at a sentencing hearing. She was entitled to early release at the halfway point, but eligible for discretionary early release under the home detention curfew provisions. If the appellant had received a single sentence of 27 months, she would have been eligible for home detention curfew for 135 days. If her sentence had felt to be calculated exclusively under the 1991 Act, the result would have been the same, and likewise, had it fallen to be calculated under the 2003 Act, it would have been 135 days. Under the provisions, the transitional provisions as construed in the Court of Appeal in this case, the eligibility was reduced by about 95 days. And we say that that is a serious anomaly. And that's a position which is repeated in many other scenarios and cases which I will seek to put before my Lords.
As far as the appellant herself is concerned, these proceedings are really of only academic interest.
Well, essentially, my Lord, yes. Save that, her position after the Court of Appeal hearing was rather uncertain, because having won in the administrative court, she had been released on HDC. Yeah. So the position of the time she spent on HDC was arguably unlawfully at large. And so it has that continuing importance for her. But with respect, the importance of this case is the principle rather than the individual.
Could you just help me? I think I worked it out, but as you've rightly said, the HDC was credit period, so to speak, was reduced so that it was stated to be the 20th of April 2008. Just looking at it the other way round, how is that made up in terms of the sentences which you mentioned treated under the two different regimes? In other words, it must be possible the reduction results from the way in which those two sentences are treated if you view them as falling under two separate regimes.
Yes, the Court of Appeal adopted the Secretary of State's view.
Just give me the figures. One calculates that she must have been in custody before sentence from.
It was 40 days on remand in custody.
Yeah. Yes.
So you go back that far from the sentence date of the 25th of May 2007
to about 13th of April or so, somewhere around there.
Yeah.
Yes.
Then you add on the 11 months from the 22, right?
My Lord, yes.
And then you add on 2.5 months, half of the 5 months sentence, less the quarter of the 5 months for which you qualify for HDC under section 34A of the 1991 Act.
Yes.
And so actually in this sort of case, the reduction in the 135 days that you would otherwise be entitled to is by definition the difference between that and a quarter of the under 12-month sentence. Because it's only
that's the net result.
Well, actually, I'm sorry, because it's a little bit variable under section, under
Yes,
whatever is the.
That's why I hesitate. It's
Yes,
actually,
that's quite right. But in a case of 5 months, it's a quarter.
Yes, indeed.
And that's how it works.
Indeed, there's a sliding scale until the prisoner
That's right.
is serving 18 months.
If it's less than 3 months, then it's 0.
0.
If it's between 3 months and 4 months, it's 30 days.
Yes.
Then it's a quarter.
Indeed.
And then, but then you're up to 135.
By 18 months, that's the threshold for the maximum.
We just find that sliding scale in, yes, it's in
It's section
page 44.
34.
34.
34A, sorry. Which is
Page
a,
page 44.
yes, divide a 7.
Well, it's convenient at page 44 of the appendix.
Yes. Yes, so,
It might have been helpful if somebody had actually explained how those statistics at page 3 of the Statement of Facts and Issues, the two competing things work. But there it is. I think I have managed to work it out.
my lord, at paragraph 6 and 7.
Yes.
Yes.
Yes, but it's not, yes, those ones, yes.
Yes, well, I'm sorry about that. The original,
In the original one, you just start 40 days back, take your 27 months, halve it, and then knock off 135 days.
yes, because the totality of the sentence is above 18 months.
Exactly.
Yes, and that's the result that the appellant says is correct.
And the reason why the licence period is longer in respect to the second is that it runs for the whole of the 22-month sentence, and there's no licence period, is there, for the 5-month sentences?
Yes, indeed, and the 5-month sentence is then, under the Court of Appeal's decision, the 5-month sentence is served during the currency of the licence for the 22-month period. So it's subsumed.
Yeah.
And it will be part of my submission that, in fact, what the Court of Appeal decision does is it converts a consecutive sentence to a concurrent sentence, because sentence 2 is served concurrently with a part of sentence 1. As a starting point, with great respect, the consideration we've just had illustrates the real difficulty with this case, that it is enormously difficult to get the right answer. And that's one of my submissions will be that the Court of Appeal's solution it creates all sorts of difficulties in practice. And that's one of the reasons that mitigates against it in terms of being the right construction of what we submit are ambiguous provisions. So the anomaly that's created in this case is actually, in our submission, quite widespread. It arises in a large number of other cases and scenarios. As we've just illustrated, it affects both the eligibility to home detention curfew, but also to licence duration. So it frequently works adversely to the prisoner in terms of HDC eligibility to a very significant degree, in this case approaching 100 days. But it also affects public protection and the prevention of crime in that it reduces significantly licence duration. And in the instant case, and in most cases that arise in practice, all of the sentences are for offences which have been committed post the commencement of the 2003 Act provisions. And therefore one would expect the transitional provisions to provide, so far as they can, for the licence duration to go to the sentence expiry date, which is the policy of the 2003 Act, rather than to give this unmerited windfall of a reduction in licence that we see in this case. My Lords, the central provision that is relevant to this appeal is paragraph 14 of Schedule 2 to the 2005 order. It may be convenient, set out in the Statement of Facts and Issues at paragraph 3. In fact, we've included in the SFI the current version of paragraph 14. It's been very, very slightly amended, and nothing turns on the amendment, so far as we say, nor indeed has learned friends have been good enough to indicate as far as they're concerned either. But that is the current version of it, and I'll come to the original version in due course, but nothing turns on that. The appellant's contention in outline is that provision is ambiguous. It's expressed in the singular, and although obviously provisions that are expressed in the singular are capable of being construed in the plural because of the Interpretation Act, the words in the parenthesis would suggest otherwise in this case. But more importantly than actually looking at the wording of the provision in this case, it's the effect of it, the context of it within the 2005 order, but also the effect of it if it's not read the way that we contend, that we submit is indicative of the correct approach to be taken to these rather difficult provisions. So I'll come back to that provision at some length, I'm afraid, in due course. But this appeal is about the proper construction of transitional provisions. Before I move on, can I indicate that it's common ground between the Secretary of State and the appellant that in fact that there is no prospect at the moment of the provisions of the 2003 Act, at which paragraph 14 is primarily directed, of actually being brought into force. So it's likely that this problem will continue indefinitely. Certainly there's no prospect of it changing in the near future. The scale of the problem, the scale of the difficulty is perhaps illustrated by the numbers of prisoners that have been submitted to home detention curfew. At page 303 of the appendix, we've shown that the total figure for offenders released on HDC is 159,000.
Sorry, page what?
Page 303.
Oh, yeah. Sorry, what is it?
About 5 lines down.
Yeah.
159,000 offenders were released on HDC between 1999, when the provisions first came into force, and the end of 2008. And in fact, at any one point, there are approximately 2,500 offenders on home detention curfew, and that is a fairly stable figure. Not all of those prisoners, obviously, will be affected by this anomaly, or the anomalies that arise from the operation of this, the difficulty in this case. We've attempted to obtain the figures for the number of prisoners who have, in fact, received sentences of more and less than 12 months. But apparently the Ministry of Justice don't have the computer system which can actually give us those figures. So that we can't, in fact, set that out. But in the recent case of Round and Dunn, the Vice President of the Criminal Division, Lord Justice Hughes, set out or indicated the scale of the difficulty. I'm not going to take you to that case at the moment, but it's actually at paragraph 8, and it's set out in my printed case at paragraph 4. And Lord Justice Hughes said, it is to be expected that up and down the country, consecutive sentences mixing terms either side of 12 months will be passed in the Crown Court on countless occasions each day. So in our submission, it's clear that this type of case, raising this type of anomaly on an ongoing basis, will happen very frequently.
Just help me with this home detention curfew. I mean, we all know it's a discretionary power of early release. I mean, do we know, how regularly it is actually exercised? I mean,
well, I can take my lord to the policy on that. It's in most cases a prisoner that is eligible for HDC, as in not presumed ineligible.
The 4 years people are presumed ineligible, but
yes.
if you're under that, then what are the likelihoods of getting it?
Well, there are, under the statutory provisions, which I'll come to, there are a number of types of offenders who are ineligible.
Quite.
Statutory ineligible.
Quite.
But most other offenders are presumed eligible. And the policy indicates that 10 weeks before, well, can I just take my lord's to it and deal with it at the moment? It's at volume 3, divider 33. This is the Prison Service Order 6700, which is the main policy document relating to this issue, and it's really key point, chapter 1 at page 2. And it's the second point. For most eligible prisoners...
Sorry, which one? Where are we going to?
Page 2.
Oh, page 2,
yeah. For most eligible prisoners, HDC will be a normal part of their progression through their sentence. They will normally be released on HDC unless there are clear grounds to indicate that they are unlikely successfully to complete the period on curfew. And then towards the bottom of the page, third paragraph up from the bottom of the page, prisoners must normally be released on HDC unless there are substantive reasons for retaining the prisoner in custody until his or her conditional or automatic release date. So there is once the prisoner is eligible, there is a presumption of HDC in most cases, and that is subject to a risk assessment. And at 5.1.1, further on in that document, the procedure is set out. 5.1.1. The risk assessment for HDC must, where possible, be commenced 10 weeks before a prisoner's eligibility date. In cases where the prisoner is not sentenced until there are less than 10 weeks to go until their conditional or automatic release date, the assessment must be commenced immediately. So that indicates that the policy is that where someone is eligible and presumed suitable, that the risk assessment should be done in good time so that they can be released on HDC at the proper time.
Sure.
Now, just whilst we're on this subject, at divider 34, there's a subsequent policy document, PSI 31 of 2006, which at paragraph 11 indicates that for prisoners serving 4 years or more, they're presumed ineligible. And as I understand it, since the 2003 Act came into force, there have been 4 such prisoners who have been released in total. So
sorry, since then only what?
Only 4 in total who have served more than 4 years have in fact been released. My lords,
I'm just pausing to reflect. I mean, I mean, if you're right, will there be some cases where you combine them all and you turn them into 4 years or more and lose them their presumption of release?
There will undoubtedly be a small number of prisoners who that would be the case for, but under the old
saved by this anomaly at the moment.
Well, the anomaly works to some extent in both directions. Primarily, it works adversely to eligibility to early release. But part of my argument is that the anomaly leads to an unwarranted windfall in licence duration. That's another generally unwelcome conclusion from the Court of Appeal decision in our submission, although to prisoners it's obviously has its advantages. Although prisoners gain all sorts of advantages by being on licence as well. They are assisted by being on licence, by having support whilst they're on licence. So again, it isn't, if I can put it this way, one-way traffic in those terms either. But that's part of the anomaly. Apart from the extent of this problem, the complexity of it is illustrated by the cases that have come before the courts. And I've set out a number of cases that have come both before the High Court and the Court of Appeal Criminal Division at paragraph 3 of my case. It's not necessary to take my lords to them, but it's a feature of those cases that they have only come to light because of the complexity of the issue and the fact that the prison administration have produced conflicting sentence calculation sheets for the prisoners. That was the position in this case, that Ms. Noone was given one sentence calculation and then she moved prison and was given another, and so the position came to light. In the case of Heighton, Mr. Heighton had actually been released on HDC, and then it came to light, according to the Secretary of State's construction, that he shouldn't have been released on HDC, and he was actually treated as unlawfully at large. And a similar position in respect of the way it came to light arose in Dunn. So it's clear this is a very complex problem for the prison staff as well as prisoners dealing with these very difficult calculations. So it isn't just the fact that it creates anomalies, and anomalies in both directions, but it's also the fact that it creates incomprehensible results, both for the prison administration and for prisoners. We've produced a number of examples, which I would like just to very briefly take my lords to at the end of our case, by way of introduction, really, to this difficult issue. And it's page 32 of our case. And we've tried to produce arithmetically relatively straightforward examples, but to cover all the possible scenarios. Mr. Giffen has been good enough to indicate that he doesn't take issue with any of these examples.
I mean, the sixth one is rather a striking one. I don't know how often it happens.
Yes. Well, it happens quite a lot, because there are often, where a prisoner is serving a sentence, there's sometimes another indictment, or sometimes something that was before the magistrate's court, another offence before the magistrate's court. So it's quite common in my submission that, taking that example, prisoner E serving a sentence of 18 months and eligible for 135 days, by virtue of getting an extra month, loses all of his eligibility. And we say that's a striking anomaly. But in each of these examples, we've tried to illustrate the anomalies that arise. If we take the first example, I'm not going to go through them at this point, but prisoner A has a totality of 2 years, and under the appellant's construction, or indeed the eligibility under either the 1991 Act or the 2003 Act, he or she would be eligible to 135 days. But because of the way that the sentence is constructed, HDC is reduced to 45 days by the decision that the Court of Appeal came to. But if we go to example 2, the prisoner is serving ostensibly the same sentence, a sentence of 18 months and 6 months, but they're being passed in opposite order. And under the Court of Appeal's conclusion, the HDC will be 135 days. So just the order of the sentence being reversed makes a difference of 90 days. And in each of these cases, we submit that the appellant's conclusion is in accordance with both of the parent acts, the before and after acts, 1991 and 2003 acts, and in some of the cases, the conclusion of the Court of Appeal is simply to reduce eligibility and to reduce licence duration. And so we hope that that illustrates the nature and extent of the problem and the anomalies that are created.
HTC is applicable only to the last term to be served. What's that follow from?
That follows from the Court of Appeal decision. Yes. The Court of Appeal decision adopts the Secretary of State's view that these transitional provisions make the more than and less than 12-month sentences be calculated separately.
Right. Yes.
And therefore it's only the last of the 2 sets of sentences which attract HDC.
Because it's what, as a matter of practicality, you could only calculate it on the last.
Therein lies another problem, because the difficulty with that, we say, is that by adopting a practical approach, the HDC on the first sentence
disappears.
It disappears.
You've got to button the second sentence onto something.
Indeed.
You can only button it onto the end of this period of custody under the first.
Yes, indeed. And the Court of Appeal indicated that one has to take a common sense approach. But it's a fact that there's a statutory eligibility on both of the 2 terms. And one of the difficulties with the Court of Appeal's decision is that it necessarily destroys the eligibility on the first part of the sentence. And we say that is a powerful indicator that is in fact not right.
I mean, the Court of Appeal's common sense solution, as I understand it, is said to be a deemed exercise of the judge's power under Section 154 of the Sentencing Act, namely to impose the second of the consecutive sentences to start on the day when the custodial term from the first one ends. Is that how it works?
Absolutely, my lord. Yes, that's completely right. Now,
was the policy behind HDC simply to provide a mechanism for lifting the lid under pressure of prison numbers, rather than any kind of rehabilitation or anything
there are
else?
2 views that it was introduced at a time of prison overcrowding, and it relieved the pressure. And then when the prison became further overcrowded, they doubled the number of days for HDC in order to deal with it. But the Ministry of Justice's position is that this is a stepping stone to full liberty, so that one is subject to some form of home detention as a stepping stone from custody. So it's actually a way of easing someone back to liberty. But my lord is right that it was introduced at the time of prison overcrowding. That's what many commentators have indicated. To return to Lord Brown's point, yes, the Court of Appeal deemed the answer to be that the second set of sentences start at the end of the custodial period for the first set of sentences under Section 154. Now, we say that Section 154 goes to jurisdiction, not to the mechanism by which the sentences are to be served, and that there are a number of difficulties with the common sense approach of the Court of Appeal. There is no jurisdiction to start the second set of sentences at the end of the first set of sentences. If one does that, one converts a consecutive sentence to a concurrent one. And we say that can't be right. Can I go to that point? I'm almost at that point of my submissions. I'm turning now, if it's convenient, to deal with the provisions.
So you say a judge simply isn't permitted, when he's passing sentence, to say, 12 months or 6 months consecutive, that consecutive term to start when you would otherwise be released from your 20-month or whatever first.
I think that's a difficult point because that isn't what happens in practice.
No, but you say that, I just want to understand dismissal on jurisdiction.
Well, in terms of jurisdiction, a judge under Section 154 could, in principle, specify a date for the start of the second sentence. But there are a number of authorities which say that judges ought not to pass partly concurrent, partly consecutive sentences. So what happens in practice is that judges simply pass consecutive sentences. So the sentencer's role is to pass a consecutive sentence. But it's not part of the sentencer's role generally to determine the mechanism or to determine how the sentences are served. So the jurisdiction, I'm going to paragraph 10 of the printed case. The jurisdiction, I've traced the jurisdiction back for consecutive sentences. It's not important, I don't think it's controversial. But the jurisdiction to pass consecutive sentences in the Crown Court is now to be found, as my Lord says, in section 154.1, which is at volume 1, divider 9. And it may be convenient just to briefly look at that. Section 154, commencement of Crown Court sentence. A sentence imposed or other order made by the Crown Court.
I'm so sorry. Which section are we looking at the 2000 Act?
Section 154 of the 2000 Act, volume 1, divider 9.
I don't think I
haven't got it.
Oh no, you had.
You've got it in page 126 in the appendix.
Yes, it's an appendix.
Yeah.
Also.
Actually, it is on the last but one page of this extract, I think. Top left.
Oh, yes. Yeah.
Is there any advantage in seeing it there as opposed to the appendix?
No, there isn't.
What page of the appendix?
£126. Thanks. A sentence imposed or other order made by the Crown Court when dealing with an offender will take effect from the beginning of the day on which it is imposed, unless the court otherwise directs. Now that preserves the jurisdiction to pass consecutive sentences. Without more, such a direction for a consecutive sentence grammatically would mean that sentence 2 starts on the expiry of sentence 1. I'm not suggesting that's sensible. I'm not suggesting that that's what should or does happen. It doesn't. But just taking the jurisdiction to pass a consecutive sentence, the court passing a consecutive sentence, grammatically, sentence 2 starts at the end of sentence 1. So if there was nothing more, the effect of section 154 and a consecutive sentence in our submission would be that the prisoner would serve their half in prison, would then be released on licence, and then would go back to prison and start serving sentence 2.
But that would be on the interpretation of what the court has otherwise directed, without any statutory intervention.
Well, what I'm getting at with respect is that it isn't section 154 which determines how a consecutive sentence runs. Parliament has always provided, as far back as we've gone, a statutory mechanism for what a consecutive sentence means. And that's of key importance here. But if we take the statutory mechanism out of the picture and we're just left with 154, grammatically, the only way that the consecutive sentence works is by having sentence 1 completed and then starting sentence 2. Now,
well, I don't see why that follows from 154. That says the sentence shall take effect from the beginning of the day on which it's imposed. It's in conflict with that to say, and the sentence on this count will be a consecutive sentence. That is the court otherwise directed.
Yes.
Yes.
Yes, I'm sorry.
Yes. Yeah, but it doesn't tell you how it's going to work.
No, absolutely.
Yeah.
My point is simply that 154 gives the judge the jurisdiction to pass a consecutive sentence, but the judge isn't directing how the consecutive sentence is to be served. And in order to make sense of modern sentences, which consist invariably of custodial periods and licence periods, and used to also include at-risk periods as well, complex sentences, in order to make sense of those and make them run properly, Parliament has provided a statutory mechanism. Now again, at paragraph 11 of the printed case, we've traced this back to 1948, 1948 Criminal Justice Act, to show that this has always been a feature of the system, that there is jurisdiction to pass consecutive sentences, but then there is a mechanism to make them work sensibly. And without that mechanism, they don't work sensibly.
Does the statutory, do these provisions also regulate how concurrent service sentences work? Because you could easily have a concurrent sentence imposed halfway through an existing sentence.
Indeed.
And they might have completely different periods of minimum detention and licence and so on.
I'm not going to tax the court's patience by going through each of these, but it might be convenient just to go to one of them.
Just before you do, going back to section 154(1), unless the court otherwise directs, on the face of it, gives the court power to direct, for example, that one sentence will start on the day it's imposed and the next sentence will start the day after. I'm not suggesting that would be done, but on the face of it,
it does.
That would be a case where the court otherwise directs.
It could.
There's nothing limiting in section 154(1).
Well, there isn't, but there's a later limiting power, which is now section 265.
Yes. But using the words concurrent or consecutive are terms of art to describe what? As far as concurrence is concerned, if the judge simply says concurrent, then that means it's going to start on the day it's imposed.
If a sentencer sentences 2 sentences on the same day to be served concurrently, they will start on that day and they will run together.
Yeah.
And effectively the longer one will determine release dates.
I beg your pardon.
If a sentence passes 2 sentences on the same day, one of which is to be consecutive to the other, one then has to look at the statutory provisions which provide for how a consecutive sentence runs. Because all that section 154 does is it gives the power, which was previously at common law, to the judge to pass a consecutive sentence. It doesn't tell the custodian who's dealing with the sentence calculation how that is to be served or the extent of it to be served.
So am I right in thinking that the word consecutive, expressed by a judge passing sentence, has in effect, a highly technical meaning?
Well, with respect, I wouldn't say highly technical. My submission is that a consecutive sentence is one which follows another. And it goes no further than that. But because we have these complicated modern sentences which have different parts, there has to be a statutory mechanism to make them work. Otherwise, as I say, the grammatical construction leads to the ludicrous position of where someone serves a custody period and then goes on licence and then goes back to prison to start the next sentence, which can't be right.
So when a judge says consecutive, he means that the one sentence will follow the other.
Yes.
But what that in turn means, from the practical point of view of how long this person is going to serve in prison or whatever other considerations apply, is something that has to be worked out later.
Well, the reason I approach it in this way is that the sentencer passes the sentence, but the custodian is then responsible for working out its extent. The defendant, if the prisoner serves too long, isn't the judge. The defendant is the custodian. So the baton is passed, if I can put it that way. The judge indicates that the sentences should be concurrent or consecutive, and then the baton is passed to the custodian, who then has to determine the extent of that sentence. And it's not for the sentencer to do that.
Mr. Weatherby, I'm just marginally troubled about the focus on section 154, because it's impossible to look at section 154 without looking at the section 51, subsection 2 of the 1991 Act, which was in force when the 2000 Act was enacted and remained in force until the 2003 Act was enacted. There's always been a very clear indication about how consecutive and concurrent sentences will work.
Absolutely.
So I'm not following why section 154 is of such crucial importance to your submission.
Well, the importance of it is that the Court of Appeal came to the conclusion that because their conclusion was that the two sentences could not be combined because of paragraph 14. And therefore, one had to fall back on section 154 and deem the second series of sentences to start at the release date from the custodial period of the first lot of sentences. And my submission is that that isn't right, because the judge passes a consecutive sentence, and approaching it in that way, it's deemed to be a concurrent sentence. So one can't combine sentences by section 154. One has to combine sentences by the mechanism that Parliament has provided. And this is a lacuna in the Court of Appeal's approach.
Sorry, so I'm just taking up Richard's point. I mean, 154, he says, it comes in force at the same time, well, while Section 51 of the 1991 Act is already in force, right?
Yes.
So what's the consequence of that? I'm looking at Section 51 at page 50.
Well, I'm coming to deal with the combining mechanisms. Can I just
Yeah,
can I just go back one step from the 1991 Act?
I see.
If it's convenient, could I just refer to the 1948 Act, just to trace the way that these provisions have progressed? But it's the equivalent to Section 51(2), and I'll come to that next. Okay. But before I do that, can I just go to, it's Volume 1, Divider 2. And it's the last copy page of that, it's Section 56. And its rules made under Section 52 of this Act may make provision whereby in such circumstances it may be prescribed by the rules, a person serving a sentence of imprisonment or ordered to be detained in a detention centre for such a term as may be so prescribed may be granted remission of such part of the sentence or term as may be so prescribed on the ground of his industry and good conduct, etc. Now that is the statutory provision for early release, and at the stage of the 1948 Act, all early release was discretionary. But the combining mechanism is then under paragraph 3 below it. For the purpose of this section, and then jumping to the last part of that section, and consecutive terms of imprisonment shall be treated as one term. So the device of the combining mechanisms was to take the terms. Let's take an example. A judge passes 1 year with another 1 year term consecutive. Under the statutory provisions, under 56.3, the custodian then adds the two sentences together 2 years and then applies section 56. Now that position was replicated in all of the other statutory provisions which we've referred to in the case. And then we reach section 51.2, which is at divider 7 of that bundle. And that maintains the same approach to all the other acts, as far as we can go back in living memory. At section 51, which is headed Interpretation, at subsection 2, for the purposes of any reference in this part, however expressed, to the term of imprisonment to which a person has been sentenced, or which, or part of which, he has served, consecutive terms, and terms which are wholly or partly concurrent, should be treated as a single term if, A, the sentences were passed on the same occasion, or where they were passed on different occasions, the person has not been released under this part at any time during the period beginning with the first and ending with the last of those occasions. So the device is the same, that a concurrent or consecutive term is single term, and then the early release provisions are applied to that single term as if the judge has passed one term, equating to the totality. Now, if we refer back, still at divider 7, to those early release provisions, we go back to section 33, the difference between the previous acts and the 1991 Act is that early release now becomes automatic rather than discretionary. And at section 33.1, we have 3 different automatic release provisions. So 33.1, as soon as a short-term prisoner, and pausing there at subsection 5, a short-term prisoner means a prisoner serving a sentence for imprisonment of a term of less than 4 years, has served one half of his sentence, it shall be the duty of the Secretary of State to release him unconditionally, i.e. not on licence, if that sentence is for a term of less than 12 months, and B, to release him on licence if that sentence is for a term of 12 months or more. And subsection 2, a long-term prisoner, under subsection 5, defined as a term of 4 years or more, automatic release, having served 2/3 of his sentence. So the device that is used up to and including the 1991 Act is that the early release provisions are expressed in the singular. The reason for that is that the sentence is combined into a single term, so that the early release provisions are then applied to a single term, as if the judge had not passed 2 consecutive or concurrent terms, but had passed a term with the totality of what that sentence is. And that is a system which doesn't lead to any anomalies, and it's straightforward, and frankly it simply works. Now, just working through the 1991 provisions, if I may, first of all, it's important to note that under 33(1)A, there's no licence, because we say that's pertinent to paragraph 14, and I'll come back and deal with that, but it's important to note the difference between A and B in our respectful submission. I'd like to deal with the HTC provisions together, if I may, so I'm going to pass over those. Section 35 brings in discretionary early release for long-term prisoners. So they're under 33(2), automatic release after 2/3, but parolable after a half. So they have a discretionary early release after a half. There have been changes to that under the 2008 Act, but they're not relevant for our purposes, so I don't intend to go to those provisions. Section 37 deals with the duration of licences, and 37(1) indicates normally that licences for both short-term and long-term prisoners last until the 3/4 point of the sentence. So that a short-term prisoner, that's what we're talking about primarily in respect to these cases, because HTC prisoners effectively have to be short-term prisoners, released automatically at halfway under the 1991 Act, on licence till the 3/4 point, and thereafter at risk of recall to prison under section 116 of the 2000 Act. Don't think it's necessary for us to go there, but just for your note, it's in the same volume at divider 9. So quite a complicated system, but it's based on single terming the multiple sentences and then applying the early release provisions. So we have the jurisdiction under section 154, and then we have the early release and combining provisions under the 1991 Act. The 2003 Act took a different approach, and it's at divider 10 in that bundle, or if my lords are working from the appendix, it starts at page 55 of the appendix. The different approach in respect to the 2003 Act is that the combining provisions are sections 263 and 264. Unless I'm asked to, I'm not going to go through the concurrent sentence provisions, because we're primarily interested here in the consecutive provisions. So, section 264, 1, the section applies where the offender has been sentenced to 2 or more terms of imprisonment which are to be served consecutively on each other, and the sentences were passed on the same occasion, or where passed on different occasions, the person has not been released under this chapter at any time during the period beginning with the first and ending with the last of those occasions. Now, the reason that that provision is in there is to prevent a judge passing a consecutive sentence where someone has served the custodial period of sentence 1 and is now on licence for sentence 1. So there's...
Well, it's the same as the old 51 too.
Yes, indeed. And in fact, that point then is made expressly clear in 265. Subsection 2 of 264 is, we say, perhaps the most important of these provisions. Nothing in this chapter requires the Secretary of State to release the offender on licence until he has served a period equal in length to the aggregate of the length of the custodial periods in relation to each of the terms of imprisonment. So, contrary to the approach of the 1991 Act, which single-termed consecutive and concurrent sentences. The approach of the 2003 Act is to calculate the custodial periods of the individual sentence and then to aggregate them. So instead of single terming and then working out what the consequences of that is, the approach here is that you work out the custodial period and then you aggregate.
Is it convenient at this point, or would you rather do it later, to see how this works, where one of the sentences is more than 12 months and the other is less? Because, as I understand, your submission is that it does work, and therefore you don't need to take out of the mix the shorter sentence under paragraph 14.
I'm in my Lord's hands. These are extremely...
I don't want to confuse matters by taking out your course. So we want to come back to that later.
I'm not very far from that.
No, let's wait.
Maybe it's a lot more logical to deal with it in turn.
Yes.
Subsection 3 then deals with the licence consequence. Where any of the terms of imprisonment is a term of 12 months or more, the offender is, on and after his release under this chapter, to be on licence, A, until he would, but for his release, have served a term equal in length to the aggregate length of the terms of imprisonment, and subject to such conditions as are required by this chapter in respect of each of those terms of imprisonment. So in effect, as long as you have a sentence of 12 months or more, not only do you aggregate the custodial periods for the period that should be served, but you also aggregate the overall sentence for the licence period to run to the sentence expiry date. Now, this is consistent with the scheme of the 2003 Act, generally, which has licences running not to the three-quarter point, as was hitherto the position, but to sentence expiry date. And it's also important in our submission that it's clearly in contemplation of the draftsperson that these provisions combine sentences of more and less than 12 months. And subsection 3 is in force.
As I understand it, you contrast subsection 3, which speaks of any of the terms, with subsection 4, which of course has not been brought into force, which talks of each of the terms.
Yes, indeed. The
subsection 4 and 5 basically preserve a limited licence period consisting of the longest licence period under any of them.
Well, the difficulty with 4 and 5 is that they relate to consecutive sentences where each of the sentences are less than 12 months. So you don't have a sentence of more than 12 months.
So you had 3 9s by...
Yes. Indeed. And the difficulty there, these provisions have not been brought into force because, as we'll see, the provisions for dealing with sentences of less than 12 months have not been brought into force.
Where do you in fact find, which section is it which defines the licence periods, or would define, if it was enforced, the licence periods for less than 12-month sentences?
Under section 181.
It's headed 181, yes.
I'll come to those. I will come to those in a moment. But and I'm going to move on to the transitional provisions in due course, but subsections 4 and 5 have not been brought into force. And in our submission, they've not been brought into force for very good reason, that if you applied the... if you take an aggregation approach rather than a single terming approach, which is what this section does, but if you use then section 33(1)(a) to calculate the periods of the less than 12-month sentences, then you end up with no licence period at all. And we say that's why these provisions haven't been brought into force. So the draftsman has noted that if these are brought into force and applied to the less than 12-month sentences, then you end up with the right answer with the custodial period, but no licence, and that's not acceptable. That wouldn't have happened under the 1991 Act if Section 51(2) had applied, because in the example that my Lord Mance gives of 3 9-month terms, one ends up with 27 months totality, single-termed under Section 51(2), and you would end up with a licence period under Section 33(1)(b). But if you deal with them separately, as is the scheme of the 2003 Act, you end up adding together the custodial periods of the 3 sentences of 4.5 months. That works. But because of Section 33(1)(a), you end up with no licence.
33(1)(a) of what?
Of the 1991 Act.
Why are you going back to 1991 Act, assuming you're now looking at the 2003 Act?
Because, as we'll see, the provisions for dealing with sentences of less than 12 months in the 2003 Act have not been brought into force.
181 is not yet in force, and that's
Indeed. So, if one, applying paragraph 14, if one is applying the old provisions to sentences of less than 12 months, as one has to do, if one takes the approach of the 2003 Act, which is to aggregate the individual custodial periods and, in effect, aggregate the individual licence periods, then you end up with the right answer of custodial period, but no licence.
But I'm sorry, I mean, I thought on any construction of paragraph 14 of the 2005 order, we know that when each of the terms of imprisonment is a term of less than 12 months, the new provisions aren't going to apply to it.
Absolutely, but we're at 4 and 5 of 264. I'm submitting that these haven't been brought into force, because if they had, they lead to that lacuna, that you end up with no licence.
They can't work until you have a statutory provision which includes a licence period for your under 12-month sentences.
Absolutely, and that's the reason that they've not been brought into force.
Where would you get that provision? By bringing Section 181 into force? Yes. Do you have to make any orders under it, or is it just automatic?
Yes, I'm just about to come to Section 181, but before I do, can I finish with 264? If we go to subsection 6, and this has become something of an important provision as well. In this section, custodial period, and then in 3 paragraphs, a meaning is given to custodial period in respect of extended sentences, in respect of sentences of 12 months and more, and in respect of certain sentences of less than 12 months, which aren't yet in force. Now,
Sorry, but what happens if it's a term of less than 12 months which doesn't comply with Section 181?
Well, this has become something of a battleground in terms of this argument, that we say that this is a non-exclusive definition, that here, subsection 6 does not define custodial period per se. It simply defines it in those 3 circumstances.
You've got to have you've got to extend custodial period further, otherwise 264(2) doesn't work.
Yes, absolutely.
But I'm sorry, I mean, are you saying, therefore, that there is another category into which you slot called term of less than 12 months not complying with Section 181?
Well, what we say is that custodial period isn't a term of art. It's not something which is requiring of exclusive definition. Now, in drafting such provisions, it's possible, of course, to say that the draftsperson has just perhaps used the wrong device and really meant to say in this section custodial period means, and to provide an exclusive definition. But in fact, the draftsman doesn't do that. Now, we suggest that the draftsman doesn't do that because it's well recognised that when new provisions relating to combination of sentences and early release come into force, there will of course be existing prisoners, and there will be prisoners to be sentenced for sentences which were committed before commencement of those provisions. And those will have to be catered for by some combining mechanism. And therefore, it leaves the position open. It gives a definition for some of the scenarios under the new provisions, but it doesn't close the door to other calculations of custodial periods. If it was to do so, it would make it extremely difficult to combine any sentences of before and after the commencement of that section.
I'm not absolutely sure I follow. I mean, subsection 6, in this section, a custodial period, and then in each of the following provisions, it means something. But what you're saying, as I understand it, is that the things where the circumstances in which this meaning is defined aren't exhaustive. There are other.
Exactly.
Well, that's why I asked you in respect of a term of less than 12 months. That doesn't, you say, cater, subparagraph 3 doesn't cater to all terms of less than 12 months.
Well, it doesn't, if I can take that in stages, it doesn't even cater for all consecutive sentences under the 2003 Act. It doesn't cater for consecutive intermittent custody sentences under section 183. So even in terms of available consecutive sentences under the 2003 Act, it isn't exhaustive.
Complying with section 181
Yes.
is a rather odd expression, because 181 applies once it's in force to all sentences of less than 12 months.
No, with respect, that's not right. That there are two. We'll come to them.
Okay.
Well, I can come to them now if it's convenient. So if we go back to 181.
It doesn't cover intermittent custody.
Yes. If we start at 181, we have, first of all, a sentence which is sometimes referred to as custody plus. And what that means is that the contemplated new sentences were custody plus under section 181, where the term of the sentence was to be expressed in weeks. Under subsection 2, must be at least 28 weeks, but not more than 51 weeks in respect of any one sentence. And 3, the court, when passing sentence, must specify a period at the end of which the offender is to be released on licence, and require the licence to be granted subject to conditions. And then at 5, the custodial period had to be at least 2 weeks, not more than 13 weeks. And then subsection 7 deals with consecutive sentences and the extent of those. And then 182 dealt with requirements under licence conditions. So the new provisions were a sea change to what had gone before. Because what had gone before was either short-term sentences where simply you served half and then were released unconditionally, or if they were combined, you might be released on licence. But here, the scheme was to have shorter custodial periods but more onerous licence conditions. And as I understand it, and learned friends will confirm or not, that these provisions have not been brought into force because they are so resource intensive. And they've not been brought into force because the provision for the onerous licence requirements have not been resourced yet. And there's no prospect of them being resourced in the near future.
But I mean, is this 181 custody plus, Is that the only thing that is said to be resource intensive that has not been brought into force?
No. The section 183, intermittent custody, again, it's not been brought into force, but this is the alternative form of sentence for less than 12 months. And this is custody where one serves a number of days, for example, weekend custody, and then returns home, perhaps back to one's job, and then goes back into custody the next weekend. So it was intermittent periods of custody with licence periods in between. In fact, this was piloted, so it was brought into force for a period in respect to some areas, but then was withdrawn. And again, as I understand it, and my learned friends, again, may be able to help more with this, as I understand it, there is no current intention to bring this into force at all.
Can I just go back to section 264? At the moment we're discussing the problem of finding a custodial period in respect of a sentence of less than 12 months.
Yes.
But I mean, by definitions, because these 4 and 5 aren't in force, such a period is still subject to the 1991 Act, release after half time. Is it?
Yes, but because it's saved by the transitional provisions, yes.
Yes. So why can't we get the period quite easily from the obvious fact that the custody period is half the length of the sentence?
Well, we say you can.
It's precisely your...
Yes.
your
I mean, and the whole problem is said to be that there isn't a definition to that effect, so
yes.
Therefore there can't be a custody period.
Yes.
Well, if I may say so, I think I see the point now, but
yes.
It seems a rather technical point.
It is.
It's not the only one.
No, it's not, I'm afraid. It only gets worse.
But where you have to ascertain the aggregate period, you can't just ignore a term of less than 12 months. Now, Section 264, 4 and 5 aren't in effect. Section 264, 6A, Roman 3, Section 181 is not in effect. You have to revert back to the existing provisions, Section 51 of the 1991 Act, which, having been repealed, is no longer repealed.
In respect of where there are 2 or more sentences, each of less than 12 months, one reverts to Section 51(2).
That's the only route you go, because you have got to find the aggregate period.
Absolutely. With respect, that's precisely our submission. But where there is a mixture of sentences of 12 months and more and less than 12 months, we say that the provision is Section 264(2), because 264(2) and 3 cater for that position. Otherwise, you fall into the lacuna that the Court of Appeal.
I'm still quite keen to see why subsection 6 is not exhaustive. I mean, I'm getting there, but in relation to sentences of less than 12 months, we've seen what section 181 does. I mean, what about these intermittent ones under 183? I mean,
that was my point about saying that even if before we even go on to consider sentences which we say are saved because they're less than 12 months and aren't catered for by 181 or 183, before we even get to that, if we stay, let me put it this way, that if we assume for the moment that all of these provisions are in force, then there is no definition within Section 264 of custodial period for intermittent custody. So it isn't exhaustive.
I see. Hang on.
If we were
how would you then work out the custodial period for a 183 intermittent custody?
Well, we would say that because it's not exhaustive, then you would simply work it out from 183.
There's a number of custodial days.
A number of custodial days. But in fact, I'm sorry to complicate this, but in fact, there's been a subsequent amendment But before I do complicate it, perhaps I can deal with this point on this before I go to the amendment. That
would mean that reading into section 2642, intermittent custody, well, that'd be perfectly possible. He would have served some days on licence, but
yes,
he'd have to serve enough days in custody.
What we say is that the draftsman meant not to make it exhaustive. That he gives definitions where there are the main likely scenarios falling under the 2003 Act.
Yes.
And we suggest, there's no more than a suggestion, that the draftsman would have been aware that there would be a lot of existing prisoners and a lot of prisoners to be sentenced for offences committed prior to commencement, and they would have to be combined. So if subsection 6 was exhaustive,
yes,
that would create a difficulty. And
yes. If you need some further understanding of the word custodial period, that's a strong argument for saying this isn't exhaustive.
yes, and there are other means of getting to custodial period. For example, 183 and 1837, in fact, deals with intermittent custody and consecutive sentences. So it's clearly within the contemplation of the draftsperson that there were to be intermittent custody consecutive sentences. It's not that there was an omission by the draftsperson in not spotting that there might be consecutive sentences. Now, just for completeness, let me alert my lords to the amendment, which effectively we say is a clarification amendment, and it's at divider 11, which is an amended version of these provisions.
This isn't in the appendix as well.
No.
So this is the amended legislation?
Yes.
And amended by what?
This amendment is the Domestic Violence Crime and Victims Act 2004, but not yet in force.
How do we know this?
Sorry, which amendment are we talking about?
I'm sorry, section 264A.
Thank you.
So it simply clarifies the calculation of custodial period for section 183 intermittent custody in respect of consecutive sentences. It doesn't amend section 264, so my point remains, we say a good one, that subsection 6 is not exhaustive.
And which bit of this do we want to look at?
Subsection 5, really, the required custodial days in relation to such term means the number of days specified under that section.
You say that's clarification, or it would be if it came into force.
Indeed. I mean, it's not enforced. We know it's not enforced because section 183 isn't in force, so it wouldn't be possible to have this in force.
Quite.
Sorry, I'm being corrected that my learned friends think it is in force. If it is in force, it's of little effect because section 183 isn't in force.
So it's in force, but not yet effective because it doesn't bite until 183 is brought into force.
Yes.
I see.
Yes, if it ever is, which is highly questionable. So, just staying within the 2003 Act, custodial period in subsection 2 is not exhaustively defined by subsection 6, which leaves the door open for other sentences not covered by the 2003 Act definitions to be included within section 2642. That's my point.
Well, what you get from section 264A is that the legislator didn't think of everything in section 2646A, which he would have thought of if he thought a bit harder.
Well, if 6 had meant to be exhaustive,
yes,
it would have been expressed differently.
Right. I mean, he clearly didn't, because he subsequently realised that
the point, the distinction I make here is that this is never meant to be an exhaustive definition. It's not an omission. It's not meant to be exhaustive.
Well, it doesn't deal with 183 at all.
No.
it might be meant to be exhaustive, but it wasn't properly thought through, and
well, that's a possible
it's an alternative, yes.
Alternative. But my point then is that what happens when you have to combine a sentence, which a consecutive sentence, say, which is passed for someone who's serving a sentence under the old regime. You have to have a combining mechanism, and if you give an exhaustive definition, then you can't then combine the two sentences, which is in fact the problem that we have.
It depends what you mean by exhaustive. I mean, if by exhaustive you mean it was intended to exclude aggregation in any other circumstances,
yes.
Then that would be detrimental to your case. If you mean that he simply believed that he'd covered all situations which needed to be covered, he may have left a lacuna which the courts would have to perhaps fill.
Yes. Well, what we say, because this is this case, we say does involve some purposive construction. It isn't harmful to my case if in fact this is an omission, because even if it's an omission, it would leave the door open for the court to purposively construe the provisions so as to make it work. But in fact, our submission is that this isn't an omission, yes. That it's by design that it's not exhaustive.
Yeah. He must have realised there were other things and just thought they were sufficiently.
Yes.
Courts could work the thing out to make sense.
Yes, it's quite an error.
Yes.
If it is an omission, because a frequent drafting device is in this section or in this act, whatever the term is, means. And 1, 2, 3, 4. Now that device hasn't been used here, and it would be very surprising if it was an omission. And we say there's no good reason to restrict the definition of custodial period. I'm sorry, and that's the answer.
Do you get a bit of help too from subsection 6b? Subsection 6a, in defining custodial period, is dealing with extended sentences of more than 12 months, and sentences complying with 181. But licence period, in relation to a term of less than 12 months complying with 181, has the meaning given by that section 3b of that section, but that's plainly not a comprehensive definition of licence period, yes. Because you've got licence periods of longer sentences.
Indeed, I respectfully agree. Staying with the 2003 Act, I've dealt with section 264, I've dealt with section 181 and 183. Briefly, can I deal with section 237? Meaning of fixed-term prisoner. In this chapter, fixed-term prisoner
sorry, what are we doing here?
I'm sorry, section 237. In this chapter, fixed-term prisoner means a person serving a sentence of imprisonment for a determinate term, or, and then B I don't think is necessary to read. I note there that in fact this definition isn't indicating that it only means 2003 Act determinate sentence prisoners. So it can refer to a person serving a sentence of imprisonment for a determinate term or already serving, for example.
Sorry, where are we? We're
237.
237.
And that's relevant to 244. Which deals with the duty to release prisoners under the 2003 Act. As soon as a fixed term prisoner, referring back to 237, again not a term of art, other than a prisoner to whom 247 applies, has served the requisite custodial period, it's the duty of the Secretary of State to release them on licence under this section. And then subsection 3, we see the different device. In this section, the requisite custodial period means. However, even here, it's not an exhaustive definition because it becomes circular by 3D. In relation to a person serving 2 or more concurrent or consecutive sentences, the period determined under sections 2632, concurrent sentences, and 2642. So although the device used here does appear to be an exhaustive definition, in fact, by referring back to 2642, which my submission for the last 10 minutes has been isn't exhaustive, it in fact covers that position also. And this is going to be relevant when we get to 246, which is the HDC provision. And if I may, I just need to deal with the duration of licences, just for completeness, at 249, under the 2003 Act. Subject to subsection 2 and 3, where a fixed term prisoner is released on licence, the licence shall, subject to any revocation, remain in force for the remainder of his sentence. So
sorry, what have you just read?
Section 249(1).
Yeah.
So the scheme of the 2003 Act is to extend licences to the sentence expiry date, which is a departure from the provisions under the 1991 Act. But under subsection 3, subsection 1 has effect subject to sections 2632 and section 2643, which we've already looked at in terms of consecutive terms. Now, can I look at the HDC provisions now, briefly? And I'm sorry to jump about a little, but the two provisions are in the 1991 Act at section 34A, which is at page 43 of the appendix, or divider 7. And I'm not going to read through them, but the provisions under subsection 1, the provisions apply subject to 2 and 3. Subsection 2 is exclusionary, and it excludes, for example, extended sentence prisoners, most sex offenders, and as we can see, various other categories of offender. Subsection 3, after the prisoners serve the requisite...
May I just interrupt you? I'm sorry. I'm not clear in my own mind. Is the extended sentence provision that we're referring to in section 34A of the 1991 Act the same as the extended sentence prisoner that we're referring to in the 2003 Act? because certainly in the 2003 Act, the extended sentences relating to a dangerous prisoner, a dangerous offender as defined. Just wondered if are we using the same language for extended?
No,
extended sentence,
under
we're
the
not, are we?
1991 Act, we're referring back to the previous form of extended sentence under the 2000 Act.
Yeah, that's just a short point, thank you.
But in fact, as we'll see in a moment when we come to the new provisions, all extended sentence prisoners are excluded from HDC. The both
Yes, right.
the both schemes. So going to subsection 3, after the prisoner has served the requisite period for the term of his sentence, the Secretary of State may, subject to section 37A below, which is a curfew licence requirement, release him on licence. And then subsection 4 is the sliding scale that we dealt with at the outset in terms of the number of days. And under little c, for a term of 18 months or more, a period that is 135 days less than the one half of the term. Now, the reason that those are in brackets is that originally they were for less days, and it's been extended.
So for a term of 18 months or more, you subtract the 135 days from the halfway point. For a term of 4 months or more, but less than 18 months, in fact, you run the quarter from the beginning of the term. No. It's not subtracted for anything. The requisite period is after you serve the requisite period, and the requisite period is a quarter.
Well, for an 18-month term, one has to serve
18 months,
18
no, you
months
subtract
less,
the 135
less
days
135
from the
days.
one half. But for a 4-month term, you actually simply just say a quarter of the term. After you've served a quarter of the term, you're eligible for release on licence.
Yes.
Yeah. So there's no question of subtracting the quarter from the half, although it reads the same result.
Yes.
And if it's less than 4 months, so you simply have an eligibility after 30 days.
Yes, but there's a minimum period that has to be served.
Yes.
But my Lord is right, beyond that, yes. Now, 37A is the curfew condition that has to be included.
I'm sorry, just going back to my Lord's point. I see. So if it's a 6-month sentence, I mean, you would only be serving 3 months, and so your eligibility starts halfway through that 6 months. I'm sorry, halfway through that 3 months.
After, 1.5 months.
Exactly.
Being a quarter of 6 months.
Exactly. Yes, exactly.
Yes, my Lord, yes. The arithmetic becomes extremely difficult, but...
What, you can't divide... Well,
no, but there has to be a minimum term served.
yes, I see that.
Yeah. So that's what complicates it. Yes. Now, section 37...
I'm sorry to go back to it. That means then, does it, that you can be released on licence before it becomes the duty of the Secretary of State to release you unconditionally?
Yes. From the 1991 Act, but only from the 1991 Act, early release became automatic.
Yes.
Generally at the halfway point. But HDC is an earlier but discretionary release date, which is why we refer to eligibility rather than actual automatic release date.
But I mean, under the policy, if you've got a 6-month sentence, chances are that you would get HDC after, as we say, a quarter of that, which is 6 weeks, yeah?
Yes.
And then after 3 months, that comes to an end because you're automatically and absolutely...
Yes. So you would then, after the 3-month point, you are not then on licence, but you are subject to the at-risk provisions of section 116 if you commit another offence.
It appears from the statistics you read us earlier that actually far more people are released under HDC than are under perhaps I haven't. Those are simply the two different regimes. What custody?
Yes, well, there will be quite a sizable proportion of offenders who will not have suitable accommodation to go to, or who are ineligible either under the statutory provisions or ineligible under the policy, which I briefly referred to. So it's not automatic, but there is a presumption where someone is suitable. So it's a very common occurrence that one would be released on HDC. Now, as I say, Section 37A involves the curfew condition, which effectively requires electronic monitoring and a curfew, which generally is for overnight, certainly, but for lengthy periods. I don't think it's necessary for me to go into that in any detail. Now, that was largely reenacted by Section 264 of the 2003 Act. The main difference between the two is that whereas under the 1991 Act you were statute barred from HDC if you were serving 4 years or more, under the 2003 Act you're not. So in theory you're eligible, but as I indicated at the outset, there have only been 4 prisoners that have been released who've been serving 4 years or more, and there is this policy presumption that prisoners will not be released. So that's the key difference, but beyond that, although there are differences, Section 246 largely reenacts the provisions of Section 34A. Subsection 4, for example, statutorily excludes extended sentence prisoners, most sex offenders, prisoners serving subject to hospital orders, etc., etc. Similar but not identical to the 1991 Act. And the calculations at subsections 2 and 3 almost exactly replicate the Section 34A calculations, but have to come at it from a slightly different direction because of the different way in which the 1991 Act and the 2003 Act calculate sentences. So the length of the requisite custodial period is at least 6 weeks under subsection 2, and he or she has to have served at least 4 weeks of the sentence and at least 1/2 of the requisite custodial period. But when one puts in the figures, an almost exactly similar position is reached as the arithmetic reaches under Section 34A. So it's clear that the legislature is trying to reenact almost exactly the provisions of the earlier provisions. Now, importantly, we need to just have a look before we move on from this at subsection 6, because this refers to the required custodial, the requisite custodial period, which determines when one can be released under HDC, and the requisite custodial period in relation to a person serving any sentence other than a sentence of intermittent custody has the meaning given by paragraph A, B or D of section 2443. Now that's important. It's horribly complicated, but it's important because if we trace it back to where we were a few minutes ago.
Sorry, what were you reading?
Yeah, subsection 2466.
Yes.
In this section, and then it's the second part of that.
Beneath A, B and C.
Beneath
yes,
A and B, the requisite custodial period in relation to a person serving any sentence other than intermittent custody has the meaning given by A, B or D of 2443. Now we did go to that some minutes ago, and just turning back to that, 2443D references to section 2642.
Sorry, 2443. There it is, yes.
So that's important because the 2003 Act combines consecutive sentences under 264, and then HDC is applicable to them under 246. And the route is through the requisite custodial period, which is through 2443D back to 2642. So that's how HDC applies to sentences combined under 264. And we say that's important because our solution is that the sentences in this case are combined under 2642, and HDC is then applicable to that because of 246.
So if you're right on 2642, then
Yes.
you're home. Because you then 2443D doesn't worry you.
That's our argument. I think the Secretary of State may have something to say about that, but our argument that's the route which we achieve that through. Now, can I turn from the statutory provisions to the statutory instrument, which is divider 12, or in the appendix at 104. Now, this 2005 order, which I know is familiar to some of my lords, was made by the Secretary of State in exercise of powers stated at the top of the first page.
This was the Stellato order, was it?
Yes, and indeed subject of the Buddington case also. Under Article 2, subject to paragraph 2 and, which doesn't concern us, and Schedule 2, the provisions of the 2003 Act specified in Schedule 1 shall come into force on the 4th of April 2005. So, moving from Article 2 over the page to Schedule 1, Schedule 1 is a list of the provisions brought into force on the 4th of April 2005. Now, the first thing to note is that sections 181 et sec are not brought into force. And there is no further commencement order which does bring them into force, save, as I say, in respect to a pilot scheme which was then withdrawn. It's paragraph 19 which is important for our purposes, and that brings into force sections 37 to 244, but not 3B and C, because they refer back to the section 181 non-commencement. 246 to 250, etc., until we get to 264. Paragraph 19 only brings into force 1 to 3 and 6 to 7. So, as we said before, this commencement does not bring into force paragraphs 4 and 5, but brings in the rest of 264. And the reason for that, as I say, is because if those were brought into force and the current sentences of less than 12 months, which aren't subject to section 181, were applied, then we would have a licence lacuna. Now, paragraph 44, 4K,
Sorry, what are we looking at?
the same schedule, paragraph 44, 1K,
Okay.
brings into force the repeal of the corresponding 1991 Act provisions that we've just been looking at, primarily sections 32 to 51. So most of the provisions which we've been looking at have been brought into force by paragraph 19, and the corresponding earlier provisions have been repealed by 44. Were it that simple, because we now have to go to Schedule 2, which are the transitional and savings provisions. And for our purposes, the relevant ones that I point to are paragraph 14, paragraph 19, and paragraph 25. And if I may, I will make some reference to paragraph 23, although that relates to recall rather than the provisions that we're actually looking for. But I say that there is an analogy to be drawn which is relevant here. Now, paragraph 14, here in its original form, which applied to the appellant in this case, and as we say, the minor adjustment that has been made to it, I think both parties agree is of no consequence, but asserts in the singular that the coming into force of the 2003 Act provisions and the repeal of the 1991 Act provisions are of no effect in relation to sentences, to any sentence of imprisonment, singular, of less than 12 months. But then has the section in parentheses, whether or not such a sentence is imposed to run concurrently or consecutively with another such sentence. And we say this can be read in more than one way. It's an ambiguous provision.
You say the obvious meaning of another such sentence is another sentence of imprisonment of less than 12 months.
Yes. And the words in parenthesis make clear that the words prior to the brackets relate to single sentences of less than 12 months.
So you either have one by itself, or you can have one which is imposed with another one.
Of less than 12 months.
Of less than 12 months, yes. And then it can either be imposed concurrently or consecutively with another one, but it doesn't cover anything else.
Indeed.
That's your submission. On the contrary, submission is any sentence means of less than 12 months includes a sentence of less than 12 months, even if it's imposed consecutively with a 22-month sentence.
That's the Secretary of State's position, and therefore it's ambiguous, and one has to look at the scheme of the order, what was trying to be achieved, and its context historically in the position before and after the transitional provisions. And we say, just taking that point further, the inclusion of the disapplication of the combining provisions is specifically required by the parenthetical phrase, if I put it that way, the words in brackets.
It's not strictly ambiguous, is it? Because of the words whether or not. If you give it its strict meaning, what's in parenthesis is unnecessary. It's merely clarifying. And if you ask why should one want to clarify in these terms, might the answer be that this is really directed to the magistrates, who are the ones who are going to be imposing these sentences of less than 12 months.
Just a bit of clarification.
Bit of clarification.
Well, if I was arguing the other side...
Yes, which you are.
If I was arguing for the Secretary of State and the words in brackets weren't there, I would simply be arguing that it was clear because the provision includes the disapplication of the combining provisions, and under the Interpretation Act, the singular includes the plural. But they are there, and they must be there for a reason. And the wording, whether or not such a sentence, is quite clear in referring back to a singular sentence. So the words in brackets give the contra indication that's referred to in the Interpretation Act in terms of the singular and the plural. So we say that the words in bracket make it clear that wherever one is considering a single sentence of under 12 months, paragraph 14 disapplies the 2003 Act provisions. But the inclusion of the combining mechanism in the disapplication is particular to the combination of sentences, each of which are less than 12 months. And if that isn't right, there's no purpose to the brackets being there at all, and they in fact don't clarify anything. So that's our argument, and we say it's ambiguous because it is capable of being read in more than one way. I think I'm in good company in terms of the ambiguity of this provision, because the courts that have dealt with this provision have had considerable difficulty in construing it, and I'll refer to that later in due course, if I may. Support for our construction of paragraph 14, we say, comes from paragraphs 19 and 25, which relate to prisoners convicted of offences committed before the commencement of the 2003 Act. And paragraph 19A disapplies various provisions of the 2003 Act in respect of such pre-commencement offences and preserves the provisions of the 1991 Act for that purpose, because to do otherwise would be to impose the new early release provisions retrospectively. And so the legislator or the draftsperson has drafted it in such a way as to disapply the new provisions for those sentences. However, what is of note is that the provision which is missed out of paragraph 19 is section 264, which is the combining provision. And therefore we say that what is trying to be achieved here is the commencement of the combining provisions, but the saving of the provisions which deal with the substantive effect of the new regime. And we say that applies equally to paragraph 14. That what the draftsperson is trying to achieve is the disapplication of the substantive provisions, or not even the disapplication because they're not ever applied, but the saving of the substantive provisions for single sentences of less than 12 months, because otherwise there aren't any provisions, because the 2003 Act provisions aren't brought into force. And they save the 1991 Act provisions and disapply the 2003 Act provisions, where we have this licence lacuna problem with subsections 4 and 5 of section 264. And that's the reason for the parentheses. So in respect of paragraphs 14 and 19, the drafting is bringing in, so far as is possible, the combination of sentences under the new Act, but saving the substantive provisions where necessary. And in that one position where each of the sentences of less than 12 months also saves the combining provisions, because otherwise it doesn't work. Now, the Court of Appeals, we'll come to in due course, adopted the Secretary of State's position that, in fact, I was wrong about that, and that 264 was missed out of paragraph 19 because one never gets to that, because section 244 is disapplied. Now, the answer to that, in my submission, is in paragraph 25, where we say it's entirely plain that these provisions do not intend to disapply the 2003 Act combining provisions of 263 and 4 because it's there in the clearest of terms in paragraph 25 that the coming into force of those provisions does not affect the date on which the Secretary of State is required to release an offender from a sentence of imprisonment passed in respect of an offence committed before 4th of April 2005, whether or not that sentence of imprisonment is to run concurrently or consecutively with one passed in respect of an offence committed after that date. So we say it's plain that the intention of these provisions is to apply the combining mechanisms in 263 and 4.
Sorry, it's plain, says that again about the combining provisions.
That when one looks at 19 and 25, that these provisions do not disapply the combining provisions of the 2003 Act to pre-commencement offences.
Is there any significance in the fact that paragraphs 19 and 25 relate to prisoners convicted and serving sentences imposed before the 4th of April, whereas paragraph 14 does not appear to have that specific, make that specific provision?
Well, paragraph 14 will primarily apply to post-commencement sentences. It will also apply to pre-commencement short-term prison sentences, but it will be rare, very rare, for an offender to be sentenced to a sentence of less than 12 months for an offence which was committed before the 4th of April 2005.
But whereas, it's my fault, paragraph 14 is open-ended.
Yes.
The offence may have been committed before the 4th of April, 1st of April 2005, or it may not. But 19 and 25 seem to be directed to ensuring that there's no disadvantage to a prisoner,
yes,
which produces an extension of the time
yes,
before he's released,
yes, they deal
following
with,
the coming into force of the 2003 Act.
Yes, they deal with a different point. Yeah. The 19 and 25 are dealing with offences which are committed pre-commencement.
That's why I'm troubled about the force you're seeking to derive from paragraphs 19 and 25.
The point I seek to make is that this section of these provisions it appears to be bringing in, so far as is possible, the combining mechanisms of the 2003 Act, but leaving where necessary either the substantive provisions or, in the one exception that we've identified with subsection 4, subsection 5, the combining mechanism as well. But primarily these provisions are bringing in the mechanisms rather than the substantive provisions, and they're saving the substantive provisions. And we say that that is because of the general approach of such legislation, which is not to apply retrospectively new release provisions unless Parliament expressly asserts as such.
It's not so much new release provision, it's, so to speak, longer licence provisions, isn't it?
Yes.
I mean, that's the offensive thing to do.
Certainly in Stellato, which is why I come back. I was going to come back and deal with section 23. Right. The reason I've dealt with it 19 and 25 before I come to 23 is because obviously 19 and 25 expressly deal with section 264. But picking up my Lord's point there, paragraph 23, as determined in Stellato, was a provision which, read with paragraph 19, was bringing in the mechanism of recall for all prisoners that was brought in by the 2003 Act, but saving the substantive provisions so as not to disadvantage existing prisoners. So we say that supports our argument here as well, in that the scheme of 14, 19, 23, 25 is to bring in, so far as is possible, the mechanism, but to leave in place the substantive provisions as far as is necessary from the 1991 Act. And therefore, we say that supports our construction of paragraph 14. The reason I put such store in paragraph 25 is because it expressly refers to section 264. So if the Court of Appeal was right about the omission from paragraph 19, that one doesn't in fact get to the position of 264 because 244 is disapplied, then why is it in paragraph 25? Now, the Secretary of State's position adopted by the Court of Appeal is that paragraph 25 applies only where one of the sentences is an extended sentence. Paragraph 25 doesn't refer at all to extended sentences, and we would say that it would be extremely surprising if paragraph 25 was there to deal with a specific point without in fact mentioning it. I've not made that point very clearly. I'll return to that, if I may, when I have a look at the Court of Appeal judgment in a little bit more detail.
It's a pretty soft nudge in the direction of your case, isn't it? It's the argument on paragraph 19 and paragraph 25. I mean, it's not. I mean, I see the argument, but it's hardly a. It's an elaborate argument which tries to derive a general purpose. It's not perhaps the strongest of your points. I don't know.
Well, I take that on board. We say that because there's this ambiguity, one has to look at what the legislature or the draftsperson is actually trying to achieve.
Yes, you say none of these provisions is intended to affect the combining provisions. They're all intended just simply to preserve the substantive sentences.
Save in the one exceptional position that we've identified in respect of the subsections 4 and 5, yes, and the parentheses in paragraph 14. And that's the point, really. Now, the other side of the coin is that the position adopted by the Court of Appeal is to disapply the combining provisions. And if that occurs, then that leaves a lacuna. And there isn't any way under the provisions by which the two sets of sentences can be combined. Can I take my lords to the Court of Appeal judgment, which is in the appendix from page 4, or in volume 2 at 24. And paragraphs 1 to 22 deal with the facts and the provisions. I don't need to trouble my lords with those. Save to say that at paragraph 17, Lord Justice Scott Baker identified the two combining provisions as being sections 51 and sections 264. At 22, the court distilled the issue. At paragraph 23, the court turned to the first of the cases in respect of which this issue had arisen, which was the case of Highton, and dealt with from 23 the judgment of Mrs. Justice Dobbs in that case. And that was a case where, similar to this case, the approach of the Secretary of State had been to reduce the HDC eligibility from 135 days, which is what it would have been under either Parent Act or indeed an individual sentence, to one of 45 days. At paragraph 25, the guidance from NOMS, National Offender Management Service, is referred to. Now that's also in the appendix. I'll just point at where that is, if I may.
I'm curious, I'm all stuck on the arithmetic of paragraph 23. 12 plus 12 plus 3 plus 3. How do you get to 32 as opposed to 30?
Plus 3 plus 3 plus 3.
Hmm?
24.
There are three-month sentences. Consecutive to the two 12-month sentences. So there's 12 plus 12 plus 9.
That's
33.
Indeed. Is that right?
No, the third 3 months is in fact concurrent. So as I was saying, it's actually 30. But it's all right. But no doubt if we look at the case, we'll find out.
Yes, I'm sorry, I don't recall. Yes, it does appear, looking back to the case, that the arithmetic.
Where's the case?
At volume 2, divider 19.
Does matter.
It's 14 months,
14 months
for the offence of assault occasioning actual bodily harm. So it's 14 plus 12.
Yeah. So the first 12 should be 14.
Yes, I'm
Yep.
afraid so. That should have been correct, and I haven't. And at 24, the position is set out as to what eligibility there would have been under the various provisions. And then at 25, the judgment sets out the guidance from the Secretary of State or from the National Offender Management Service that was given to prisons as to how to calculate sentences and administer the HDC scheme, because as NOMS had spotted that there was, on their version, a lacuna in the provisions. And if we look at the last 3 lines of the page, 1328, paragraph 25, there will of course be transitional cases where a number of consecutive sentences are given, some being 12 months or more and some being under 12 months. We take the position that the 1991 Act therefore applies to those sentences under 12 months, and the 2003 Act applies to those of 12 months or more where the offence was committed on or after the 4th of April 2005, and then goes on to deal with their version of how that should work. At 26, the policy document is then summarised. Ms Seddon went on to observe, as is the case, that whether the 1991 Act sentence or the 2003 Act sentence is treated as being served first can have a significant impact on HDC eligibility, as indeed it can on the licence period. Prison governors were directed as a matter of policy to proceed on the basis that the sentences were to be served in the order imposed by the court so far as this was possible. 4 other options were considered but rejected. And then at 27, it's pointed out that the policy that was being applied was not under challenge in Heighton, although it was in the current case. And that Mr. Justice Mitting, in this case, held that it was unlawful, concluding at paragraph 32, the only policy capable of giving effect to the policy of the 2003 Act and to the rational expectations of prisoners dealt with under both Acts is to ensure that they were not disadvantaged in relation to HDC, but are subject to the maximum period of licence on release, which can lawfully be imposed. The appeal of the Secretary of State at 28 is that Mr. Justice Mitting was wrong in finding that the policy was unlawful, but alternatively that it wasn't a policy at all, but simply a matter of applying the legislation to the sentences imposed by judge. The position in Heighton had been, in effect, that the Secretary of State accepted that there was a lacuna and that the lacuna was filled by the policy. The Secretary of State sought to argue in the alternative that either the policy was lawful or that it wasn't a policy, it was simply applying the legislation to the sentences imposed by the judge. Lord Justice Scott Baker then indicates that he would return to the question of policy, but went on to consider the constructional argument, and at 30 dealt with the argument before Mrs. Justice Dobbs. At 31, in rejecting the claimant's argument, accepted that there was force in the submission that paragraph 14 is ambiguous, in particular indicating that the heading saving for prisoners serving sentences of less than 12 months could be interpreted to mean prisoners only serving sentences of less than 12 months. And moreover, the references in brackets in paragraph 14 to such a sentence and such sentence are also, in the light of the remaining part of the paragraph, also ambiguous. But then Mr. Justice Dobbs expressed her conclusions in the judgment, which was cited with approval by Mr. Justice Mitting at paragraphs 39, and again that starts accepting that the phrasing of paragraph 14 may be ambiguous, but then accepts the construction advocated by the Secretary of State as being correct. And in particular, at 5, towards the bottom of that section, indicates that the claimant's interpretation involved mixing 2 different regimes. Because this was not made explicit in the order, nor was there any indication that this was the desired effect, given that two different and separate regimes are contemplated. In any event, it is highly unlikely. Then at 40, the judgment of Mrs. Justice Dobbs. I'll turn now to the claimant's submission that it is the Secretary of State's construction which has caused the anomalies. she concludes 8 lines down on the next page that it's the policy, not the provisions, which achieved that position, i.e. the anomalies. There is no mechanism either in the Act or the order for combining the two regimes. And this is why the Secretary of State has formulated a policy to deal with these situations. Now,
why does the claimant's your interpretation involve mixing two different regimes?
Well, in a way it does. That's right.
Well, doesn't the Secretary of State as well, in a way? I mean, you apply different perhaps he doesn't mix them. He applies them separately.
Yes,
but in a way which undermines the provisions of one of them.
Yes, with the Secretary of State solution, one ends up with 2 different bags of sentences, 2 different parts to the sentence without a combining mechanism. So at the stage of the argument in Highton, the Secretary of State was saying, well, we can fill this lacuna by a policy.
Yes.
And that was accepted by Mr. Justice Dobbs. But our solution does in fact mean that you combine the 2 sets of
yes, of course.
sentences, but then apply the Parent Act to the calculation of custodial periods. So to that extent, Mr. Justice Dobbs was correct about the combining. We would submit she wasn't correct that the transitional provisions don't lead to that, because that's what paragraph 14 does lead to. At 32, Mr. Justice Mitting felt himself unable to escape from what he described as the unattractive conclusion reached by Mrs. Justice Dobbs, but adopted her reasoning.
The last sentence is wrong, isn't it?
Yes. My Lord's ahead of me. I'm just coming to that. That's precisely not what the appellant's position is. It's right at 33 that the appellant submits that a grammatical construction favours his argument, but what is critical is the context and purpose of paragraph 14, and then it sets out various of the points that were made. As I make those submissions essentially today, I shan't go through them, but at the bottom of the page, I won't go through them at the moment, but at the bottom of the page, 4 lines up, there is a strong presumption that the draftsman intended the transitional provisions to deal with such a situation and achieve results as close as possible to the Parent Acts, and he submits that this construction does so. And then deals with a singular rather than the plural part of my argument. And I reiterate that our solution does, in fact, in each of the examples that we've provided, and we say that in any scenario that is thrown up, provides the same eligibility date as in either of the Parent Acts, and it adopts the licence duration of the 2003 Act. And of course, in this case, all of the offences are committed after the commencement of the 2003 Act. So again, one would expect that transitional provisions would provide for the new policy on licence duration. So we say it's consistent both in terms of eligibility and licence duration. Paragraph 34, the court turns to the main objection to the appellant's argument, in that it's not possible to calculate the custodial period for sentences of less than 12 months, and then goes through the appellant's argument that custodial period is not a term of art, and that can be shown from subsection 6.
You covered this, haven't you?
Which we've dealt with.
Yes.
The 37, the court deals with the Secretary of State's essential point is that the fallacy in the appellant's argument is his proposition that the time to be served in custody in a case of consecutive sentences is provided for by section 2642. It is this that enables him to go on and argue that this provision is not disapplied in the case of consecutive sentences for old and new offences, because section 264 is not one of the provisions listed in paragraph 19, and because it is in paragraph 25. Secretary of State exposes the fallacy. Thus, the relevant section is not section 2642, but section 2441. This is the section that places the Secretary of State under duty to release the prisoner after he's served the requisite custodial period. And therefore, in effect, that it was section 244 rather than 264, which was the operative provision.
I think the Court of Appeal use new, as I understand it, to mean...
Post-commencement.
What?
Post-2003.
Well, not only post-amendment, but less than... I'm sorry, but more than 12 months, don't they? I thought I had found that somewhere. I may be wrong. I may be wrong.
I'm sorry, I don't have that.
I thought I'd picked that up somewhere.
Point in mind. My Lord may well be right.
Wait a minute. Paragraph 3 of the judgment. For convenience, I shall refer to an offence committed before as an old offence, an offence committed after as a new offence, provided it attracted a sentence of 12 months or more.
Yes, my Lord's quite right. Yes. At 40, the court indicates that once it recognises it's section 244 and not 264, that's the operative provision, it can be seen that the relevant 2003 Act provision is disapplied by paragraph 19 in respect of old offences. Paragraph 19 expressly says that section 244 inter alia is of no effect in relation to a prisoner serving a sentence of imprisonment imposed in respect of an offence committed before the 4th of April. Because 244 is disapplied, one never gets to section 264 in such cases, because the section 2443A, incorporation by reference, does not apply. I think that must be 2443D.
B.
D.
D.
I think. Do you agree? Accordingly, there's no need for section 264 to be separately disapplied for this purpose. Thus, it's wrong to say, in the case of consecutive sentences for old and new offences, there is a need to apply section 264 of the 2003 Act. And this must involve deriving a custodial period from the 1991 Act. Because section 244 is disapplied to the sentence for the old offence, section 264 is irrelevant in determining when the prisoner falls to be released from that sentence. And then the court concludes that the Secretary of State is right for that reason. Although it goes on to deal with paragraph 25. And paragraph 25 is the difficulty we submit with the Secretary of State's submission here. Lord Justice Scott Baker goes on to say, I'm satisfied, although it is irrelevant to the outcome of the present appeal, that paragraph 19 operates in the same way as paragraph 14 by requiring separate treatment of sentences for old and new offences. This is perhaps hardly surprising, as both paragraphs, as their headings show, are concerned to make savings for a particular type of sentence, which is to remain subject to the 1991 Act. As to paragraph 25, which is again not relevant to the outcome, Mr. Giffen points out that this paragraph is concerned only with a situation where there are consecutive or concurrent sentences for a mixture of old and new offences, and those include an extended sentence. Well, we say therein lies serious difficulty for this analysis.
Well, one day you'll have to explain it to me again, because I'm not sure I've really grasped that one.
So, if section 264, going back to the wording of the 2005 order, if section 264 is not disapplied by paragraph 19, then it is still there because of paragraph 19 of Schedule 1. It's brought into force.
Sorry, we're looking at 25 of the second schedule, are we?
We look at 19 and 25 of the second schedule.
Yeah.
If section 264 is not disapplied by paragraph 19, then it is there because it has been brought into force by paragraph 19 of the first schedule.
Wait a minute.
Now, the Secretary of State's argument adopted by the Court of Appeal is that it's not there because you never get to it.
But it must be there because section 25A says it's there.
Exactly. That's precisely the point. And the adopted argument at paragraph 43 of the Court of Appeal judgment, we say just can't be right because there is no mention of extended sentences in paragraph 25. And there is no reason why one should assume that it refers only where there is an extended sentence. And it's plain, we say, from the drafting of paragraph 25, that the purpose of 25 is to modify the way that section 264 applies. And it isn't simply to apply it where there are extended sentences.
So where do we just see that reference to extended sentence? Paragraph 43.
Yeah.
So you say that's wrong.
But if we look at 25,
Yeah.
there is no reference in 25 to extended sentences. What it does say is the coming into force of 264. First of all, it recognises that it's not an omission. It does not affect the date on which the Secretary of State is required to release an offender from a sentence of imprisonment passed in respect of an offence committed by the 4th of April. Whether or not it's to run concurrently or consecutively with one passed in respect of an offence committed after that date.
So it's simply defining the date when he's required to release.
But it's contemplating that there will be aggregation.
It expressly recognises that the combining mechanism will apply where there is a pre- and post-act provision. I mean, we say you can't read that any other way because when it says to run concurrently or consecutively with one passed in respect of an offence committed after that date, is expressly contemplating the mixing of sentences pre- and post-commencement, which are combined under section 264, and it's simply saying that the application of 264 doesn't affect the custodial period for the 1991 Act offence. So it's recognising that you combine the pre-Act and post-Act offences under 264, but you calculate the custodial period under the relevant parent Act. I know this is extremely difficult. I hope I've made that.
Well, I would like on half a sheet of paper an illustration of section 25 in operation as to how taking sentences before and after, how you say it would work but for this and does work because of this.
Well, I will certainly supply that.
Thank you.
I will try and do that over the short adjournment.
Well, let's start that now then.